back to the Wealth and Wellness Club. I'm Jennifer Polich, and this is Chrissy Reilly, and we are real estate agents in Orange County, California.
Today we have Kylie, Ruhlen, and Tracey Culley-Rojas here from Orange Coast Title Company, here to educate us on the various ways that we can hold title when purchasing real estate.
So Tracey, please tell us, what are the options for holding title and what are the differences between them?
Great question. There are multiple ways of acquiring title to real estate, and those couple of words, whether it's joint tenants, which is one of them, tenants in common, those 2-3 words are very powerful. I'm going to get into a few different ways of acquiring title. And today I'm going to be presenting information relating to a buyer and seller guide that we have. It's a tool that we have. It's available. It's page 40 and 41 of this buyer and seller guide. And I'm going to share screen with you right now, one of the pages in that buyer and seller guide so you can see what I'm referring to. Now, this is a good go-to for information relating to those ways of acquiring title. The 4 most popular ways currently of acquiring title in California are tenancy in common, joint tenants, community property, and community property with the right of survivorship. Each one of them is very different, and they have an impact relating to probate, property taxes, actually taxes in general, and it's very, very important that a buyer be comfortable with it. But not only that, that an agent understands some basics relating to it too. If you take a listing and let's say you have 2 people on title, if they're on title as joint tenants, what does that mean to you if one of them has passed away as an agent with regards to how long your contract could be, for example? So we're going to get into that, how it does have an impact. We're going to begin with tenancy in common, this first one here. And for today's purposes, I'm going to cover a few basics. We can always get more into it at a later time. So tenancy in common, this very first row, tenancy in common, any number of persons can be tenants in common. Now, those words, tenancy in common, to me, it sounds like we're all together in this, which we are if we own property together as tenants in common. However, tenancy in common actually separates our interests, and I'll explain that. Now, when somebody acquires title, they're going to have their name indicated, the name that they want to acquire title in, but they're also going to have their status, whether they're a single man, single woman, married woman, or unmarried if they're divorced. It'll be clearly stated, their name and their status. But in addition to that, there's always a vesting, how they hold title together if there's more than one person. There will be a vesting, which means indication to the public, and the public record will show the deed where they say how they share their interests together. Now, if they share it together as tenants in common, and again, that can be any number of people holding title as tenants in common. Kylie, Jennifer, Christy, and I could hold title as tenants in common, all 4 of us. We do need to indicate, if we're tenants in common, what percentage we each have, whether it's 25 each, or we could have different percentages. I could have 20, and Jennifer, you could have a different percentage. It doesn't have to be the same percentages, but we should indicate what our percentages actually are. And our interest to our percentage, if we're tenants in common, our interest is completely separate. There is no right of survivorship, which means if one of us were to pass away, our percentage doesn't automatically go to the others. In fact, it's separate because we're calling ourselves tenants in common. Our percentages for each of us are separate to ourselves. There is no right of survivorship. So if one passes away, let's say, for example, my percentage, I hold my title as just simply a married woman, sole and separate. Well, if I were to pass away to my percentage, it would have to be probated. And the importance of this is if you acquire title with other people and your tenants in common, your interest is totally separate. If one of them passes away, then you are on title with their heirs to their percentage, and a probate would be needed if they were on title to their percentage as an individual. This is a really big deal because for a real estate agent, if you see tenancy in common, 4 people on title, 1 passes away, you know that one's interest does need to be probated. If they're on title as an individual, that could extend your contract date. It could be a 45, 60-day contract versus joint tenancy, which I'm going to get into. Now, joint tenancy is very different. Joint tenancy, the beauty of joint tenancy is it avoids probate altogether. With joint tenancy, there is what's called a right of survivorship. It's one of our oldest vestings in California. It was typically used 150 years ago. I would see deeds when I was a searcher with the vesting of joint tenancy for husband and wife. That was very common. But anybody can be a joint tenant. The difference is with joint tenancy, we all share, we all have the same interest. We are really all in it together. If there are 6 of us, we all have the same percentage. We don't even need to indicate it. It's automatically assumed we have the same interest. We all need to acquire together as joint tenants and with the right of survivorship that joint tenancy has. If one of us were to pass away, our interest would automatically go to the others. No need for probate, no need for court, judge, attorney, no need for any of that. The beauty of that is if one person passes away, you could actually take a 10-day all cash. All that would need to be done is an affidavit, death of joint tenant, to account for the death of that owner. That would be recorded. And that's it. The right of survivorship is a beautiful thing. Now, going back to tenants in common, if one of those percentages was held in a trust also can avoid probate. So that's the great thing about a trust specifically. We can always get to trust in a future conversation. Now, community property is only for married persons or domestic partners. So community property, when you see that vesting, we're talking about married persons or domestic partners. And the beauty of community property, they indicate that after their names, the owners, they do have the right of survivorship with community property as well. However, it's a little bit of a unique scenario. Community property has a right of survivorship if there's no will contesting the interest automatically going to the surviving spouse. So let me explain that. Community property, if 2 people are on title and they're married or domestic partners, if one of them passes and they just have the words community property, their interest will automatically go to the other, and the one that's surviving can record the affidavit, death of community property interest of the spouse. They can record that to account for them. However, on that affidavit, it asks, or it actually states, and they need to sign that document, that they know of no will that would contest them claiming this interest. There's a line in the affidavit itself. So a will could challenge the interest automatically going to the spouse if there's one that is existing, and that affidavit does state that there isn't one that's known of, and then they claim that interest. Now, you notice that last row is a little different. Community property again, but this time with right of survivorship. So community property with right of survivorship, again, we're talking just a few different words, right? With right of survivorship, by adding those 4 words, the impact is significant, because by saying with right of survivorship, like with joint tenancy, automatically if one passes, their interest goes to the other, and they're telling the public they want that right of survivorship. So it would be very difficult for a will to contest that, because they've already told us clearly by putting that on their deed and having it recorded that they want that right of survivorship. They want their interest to go to the surviving spouse. So it's very important. And that difference, that is the most recent vesting in the state of California, community property with the right of survivorship that's used pretty commonly. So those, again, look at these words. I mean, it's just a matter of a few words, right? Tenancy in common, joint tenants, community property with right of survivorship. In total, what do we have there? Maybe 12, 13 words, something like that. Look at how powerful those words are, though, right? So these words are legally binding. They are reliable. We can look to them and know exactly how to proceed. I think the most important takeaway in this conversation is know the power of these words more than anything. You don't have to be an expert. You can always reach out to us. We can walk you through what they mean and the impact they have, but know that they have a very significant impact, and how to proceed in the future will be determined by how they actually are holding title. Great for buyers to know, great for real estate agents to know. And again, we have our buyer and seller guide. We can give you access to that as well. And I appreciate being able to talk to you all today. Jennifer, thank you so much for having me join.
So Tracey, thank you so much for all that information. Can you just tell us a little more about what is the difference for a married couple between holding title as joint tenancy versus community property with the right of survivorship?
There may be an impact with regards to taxes. And whenever a buyer is acquiring title, they definitely want to make sure that they talk to an attorney if they have concerns relating to the property itself, and also to a tax accountant, because joint tenancy and community property can have what's called a step up tax wise, so it can impact them. There certainly can be a difference in that. They should consult with an attorney relating to that. And remember, joint tenancy versus community property. Joint tenancy is like the last row with spread of survivorship. So community property can be contested with a will, or joint tenancy would not. So that's a big difference.
Thank you so much, Kylie and Tracey, for this awesome information. I know our viewers will really benefit from knowing the differences of how to hold title.
Yeah, at every transaction, I get the same question. So I know a lot of homeowners need this information.
Absolutely. So if you guys liked this video, be sure to give it a thumbs up and subscribe to our channel so that you don't miss any of our future episodes in regards to the Wealth and Wellness Club.
See you next time.
Bye.